Afternoon, everyone. I am Maris Paulo. This is the part 2 of the chapter 13, which is the government institutions. So we are now on the topic of impeachment. So impeachment is a formal proceeding wherein a high official of the government is charged with misconduct in office. If the official is found guilty, that is, convicted of an impeachable offense, then such official will be removed from office without prejudice to prosecution for possible criminal offenses. So, yung impeachment daw, ito yung isang formal proceeding na pwedeng maisagawa sa isang high official kapag nagkaroon siya ng offenses sa government or sa kanyang position. So, at present, meron daw 9 impeachment proceedings conducted by the Philippine Senate. So, sa 9 proceedings na yon, only 3 officials were removed from the office. So, let us find out why. So, in 2011, there's the House of Representatives impeached Ombudsman Merceditas Gutierrez, but before the Senate could try the impeachment case, Gutierrez voluntarily resigned from the office, thus making the impeachment trial unnecessary. So, yon sabi daw noong 2011, merong final na impeachment kay Ombudsman Merceditas Gutierrez, pero since na nag-resign muna siya bago maisagawa yung isang trial, so hindi siya nangyari or natuloy yung impeachment. In 2001 naman, the impeachment proceedings against President Joseph Estrada were halted when the prosecution panel walked out to protest the refusal of 11 senators to open the envelope containing what was perceived in incriminating evidence against Estrada. The strategy of these senators prompted what Chief Justice Renato Puno called the extra-constitutional removal of Estrada. So, these are the impeachable officials. Ito yung mga officials na pwedeng ma-impeach. Under Section 2 of Article 11 of the Constitution, the only officials who may be removed by impeachment are the following. So first, pwede yung President of the Philippines. Next is the Vice President of the Philippines. Third, Justices of the Supreme Court. Fourth, members of the Constitutional Commissions. For example, is yung Chairman and Commissioners ng Civil Service Commission, COMELEC, and the Commission on Audit. And lastly is yung officials or part ng ombudsman or yung mismong ombudsman mismo. So these are the impeachable offenses. The same Section 2 of Article 11 also provides for an exclusion list of offenses which may be the basis of an impeachment complaint. These are culpable violation of the Constitution, second, treason, third, bribery, fourth, graft and corruption, fifth, other high crimes, or betrayal of public trust. Next, presidential succession politics is politics. Section 7, Article 7 of the 1987 Constitution states that the President-elect and Vice President-elect shall assume office at the beginning of their terms. So, this may not always happen. For one reason or another, a vacancy in the office of the Philippine President may arise even before the term is served or during such service. Section 7 also provides for such eventuality. So una, if the President-elect fails to qualify, the Vice President-elect shall act as President until the President-elect shall have qualified. So first daw kapag merong issue about the President-elect or based on the qualification, yung Vice President-elect daw muna ang magiging President until na maging qualified na yung president-elect. Number 2, if a president shall not have been chosen, the vice president-elect shall act as president until president shall have been chosen and qualified. So kapag, for example, ito yung case na tallied and alam na kung sino yung vice president pero yung president is hindi pa. So this could happen. Third, if at the beginning of the term of the president-elect shall have died or shall have become permanently disabled, the vice president-elect shall become president. So in this case, sinasabi dito na sa first term ng president, for example, is namatay siya or nagkaroon siya ng sakit which could lead to possibility na hindi niya magampanan yung position niya, pwedeng maging president or pumalit sa position niya is yung vice president-elect. Number 4, where no president and vice president shall have been chosen or shall have qualified, or where both shall have died or become permanently disabled, the president of the Senate, or in his inability, the House Speaker of the House of Representatives shall act as president until president or vice president shall have been chosen and qualified. So number 4 naman, ito naman yung kapag hindi available yung president or vice president. For example, dun sa case na namatay yung president, tapos ganun din yung vice president. So ang papalit sa kanya, sa vacancy ng presidency is yung President of the House of Senate. So kapag hindi naman siya pwede, yung President ng Senate is yung Speaker of the House of Representatives. So pababa siya ng pababa. Section 8, in case of death, permanently disability, removal from office or resignation of the President, the Vice President shall become the President to serve the unexpired terms. In case of death, permanently disability, removal from office or resignation of both President and President, the President of the Senate, or in case of his inability, the Speaker of the House of Representatives shall then act as President until the President or Vice President shall have been elected or and qualified. So, ito nga yung sinasabi in case of death or yung mga ganong scenarios. Vacancy in the office of both the President and Vice President. Section 10, Article 7 of 1987 Constitution deals with the remote possibility of vacancies in the office of President and Vice President occurring at the same time. So, the same provision also states that the special election should be held not earlier than 45 days, not later than 60 days from the time such called. So, if vacancy occurs within 18 months before the date of the next presidential election, however, no special election shall be called. The bill calling such special election shall be deemed certified and shall become law upon its removal on third reading by the Congress. So, the short period given for the holding of the special elections underscores the need to immediately fill up the vacancy. The only time when no special election is called is when the vacancy occurs within 18 months prior to the holding of the next scheduled presidential election. So, it tackles about kung kailan mangyayari or possibility that special elections could happen. So, next one, temporary disability of the President. Section 11, Article 7 of the 1987 Constitution covers instances when the President is temporarily unable to discharge the duties of the Chief Executive. The declaration can be done in writing by the President himself or by a majority of all the Cabinet members. So first, whenever the President transmits the President of the Senate and the Speaker of the House of Representatives his written declaration that he is unable to discharge the powers and duties of his office, and until he transmits to them a written declaration to contrary such powers and duties shall be discharged by the Vice President as acting President. So, ang magiging acting President is yung Vice President. Number 2, when a majority of all members of the Cabinet transmit the President of the Senate and to the Speaker of the House of Representatives their written declaration that the President is unable to discharge the powers and duties of his office, the Vice President shall immediately assume the powers and duties of the office as acting President. So, and then the vacancy in the office of the Vice President. Section 9, Article 7 of the 1987 Constitution deals with instances involving a vacancy in the office of the Vice President. To fill the vacancy, the President shall nominate a Vice President from among the members of the Senate and House of Representatives. Before the nominee can assume the office, the nomination is subject to the confirmation by a majority vote of all members of both houses of the representatives. So, ito naman, sa vacancy in the office of the Vice President, magkakaroon ng nomination sa Vice Presidency or sa vacancy ng Vice President between sa Senate and the House of Representatives. So, doon siya mamimili kung sino ang ipapalit at yun ang pagbobotohan. Next, let's go on with the political dynasties. Section 26 of Article 2 of the 1987 Constitution prohibits political dynasties. Thus, the state shall guarantee equal access to opportunities for public service and prohibit political dynasties as may be defined by law. So, ito sinasabi daw sa Section 26, Article 2 of the 1987 Constitution. Ginaguarantee daw ng state yung equal access sa opportunities ng public service. Pero, dito nga sa atin is kahit merong equal opportunities, mas kilala ka or kapag nasa political dynasty ka, mas madali kang makikilala and ma-elect ng tao sa position na gusto mo. So, Father Joaquin Bernas, he is a member of Constitutional Commission which drafted the 1987 Constitution. The prohibition was placed to provide equal access to public office. This constitutional provision, however, is not self-executing as it requires an enabling law to define what political dynasties are. So, si Father Joaquin Bernas daw is a member of the Constitutional Commission who drafted the 1987 Constitution. So, isa siya sa sumulat nung 1987 Constitution with the prohibition of equal access to public office. So, House Bill number 837, authored by Representative Erlinda N. Santiago. This which reached the plenary on May 6, 2014. Not many are willing to support the enactment of the law that would prevent relatives of elected officials running to the same or other elective office. So, hindi siya supported ng ibang officials. So, siguro maybe sa kanilang family, meron din gustong tumakbo ng ulit-ulit or kahit sino sa family nila. Kaya hindi siguro sinuportahan yung House Bill number 837. It is not difficult to understand the reason why. So, House Bill number 837 itself defines political dynasty as the concentration, consolidation, or continuation of public office and political power by persons related to each other. In Representative Santiago's bill, a political dynasty relationship exists when a person who is the spouse of an incumbent elective official or relative within the second civil degree of consanguinity or affinity of an incumbent elective official holds or runs for an elective office simultaneously with the incumbent elective official within the same province, or occupies the same office immediately after the term of the office of the incumbent elective official. So, doon sa kanyang House Bill number 837, doon niya diniscuss or dinescribe kung ano yung political dynasty. So, yun nga daw yung kapag ang isang elective official is may spouse or other relative na possible na tumakbo din sa isang elective office sa government or sa province na kinabibilangan niya. The same bill states that the political dynasty relationship also exists. So, where two or more persons who are spouses or are elected within the second civil degree of consanguinity or affinity run simultaneously for elective public office within the same municipality. So, pag meron daw parehong municipality, city, or province, even if neither is so related to an incumbent elective official. So, isa din daw yon na other terms for political dynasty. So, Ronald U. Mendoza, Edsel L. Beja Jr., Victor S. Vinida, David B. Yap. So, they made a study where they explored the connection between poverty and political dynasty. They found out that political dynasties dominate where there is extreme poverty. These analysts believe that the government strike can have no choice but to rely on patron-client relationships, which perpetuates political dynasties. The solution to the elimination of these political dynasties is a comprehensive poverty reduction and social protection program, which will foster an inclusive democratic leadership. The analysts therefore suggest that political reforms may be instituted to enable Filipinos to break out the dynasty. So, based doon sa research nila Ronald, Edsel, Victor, and David, nakitaan ng political dynasty sa mga provinces na mayroong high poverty rates. So, last, the Ombudsman and the public accountability. Section 2 of RA number 6770, the Ombudsman Charter, states that the state shall maintain honesty and integrity in the public service and take positive and effective measures against graft and corruption. So, ito daw yung trabaho ng isang ombudsman. So, which is to maintain the honesty and integrity ng mga public officials. The citizenry supporting the operations of government with taxes deserve no less than honest and graft-free elective and appointive officials. Public office is a public trust. So, yun, quoted, public officers and employees must be at all times be accountable to the people, serve them with utmost responsibility, integrity, loyalty, efficiency, act with patriotism and justice, and lead modest lives. So, eto daw yung role ng mga public officials, which should be on the benefit of the public itself. So, this picture, it is the office of the Ombudsman. The Office of the Ombudsman investigates and prosecutes on its own or on complaint by any person. So, pwede daw sila yung magbigay ng complaint dun sa isang public official, or sila yung mag-solve doon sa isang complaint ng any person in a public. Or any officer or employee or office or agency. So, kahit agency, pwede silang lumapit sa ombudsman kapag meron silang nakikitang mali or meron silang complaint to any of the public officials. The investigative process may begin with administrative complaints lodged before the Ombudsman, also called the Tanul Bayan, under Section 19 of RA number 6770. The Ombudsman shall act on all complaints relating but not limited to acts or omissions which, first, are contrary to law or regulations. So, ito yung mga pwede nilang imbestigahan. Are unreasonable, unfair, oppressive, or discriminatory. Are inconsistent with the general course of an agency's function. So, pwede yun. True in accordance with law. Next, proceed from a mistake of law or an arbitrary ascertainment of facts. Number 5, are in the exercise of discretionary powers but for an improper purpose. Or number 6, are otherwise irregular, immoral, or devoid of justification. So, even an administrative complaint can be the basis of preliminary investigation by the Ombudsman of the government official or employee for possible commission of criminal offenses. So, the Ombudsman can also investigate under Section 22 of RA number 6770, which is any serious misconduct in office or yung mga behavior ng mga officials in the office allegedly committed by officials. So, sila yung pwedeng officials which can be removable by impeachment. Aside from the power to investigate, the Ombudsman is also clothed with the power to inquire into acts or omissions of a public officer. So, sila rin yung may kakayahang magpaalis ng isang public official, employee, or yung office, or kahit agency, based on sa reports and complaints na natatanggap nila. So, the Ombudsman or the Ombudsman deputy is considered to be, first, contrary to law or regulation. Next, unreasonable, unfair, oppressive, irregular, or inconsistent with the general course of the operations and functions of a public officer, employee, office, or agency. An error in the application or interpretation of law, rules, or regulations, or a gross or palpable error in the appreciation of facts. Next, based on improper motives of corrupt considerations, unclear or inadequately explained when reasons should have been revealed. Lastly, inefficiently performed or otherwise objectable. So, that is the report about the chapter 13, the government institutions. So, I hope you learn something about this lesson. So, that's all. Thank you.